Hello and welcome. A little feedback here. Hello, welcome. My name is John O'Brien from the Keystone Contractors Association. Welcome to today's program, Ask the Attorneys, Part 2. Many of you might recall we hosted this last spring of 2020. And actually, Micah Sales, who's on the call here, he was on another event that we hosted about a month ago. And Micah said, you know, the best program you hosted last year was when you had the attorneys on there and we were firing away with questions. And he made that comment, and others on the line were like, yeah, that was a good program. You know, I wonder if those gentlemen would like to do it again and see what questions the industry have. So thanks for that idea, Micah. You got it, brother. But yeah, welcome to today's program, Ask the Attorneys Part 2. And our esteemed presenters and speakers today, you see on your screen. We have Matt Jameson from Burns White to the left, Tom Williams, Rieger Adler, David White, Babs Callan, Michael Metz-Topodas from Cohen Siglius. One of these years I'll get that name right. Don't worry, brother.
It's those Greek names. I'll throw you for a loop every time.
There you go. But, you know, first off, I just want to thank you guys for taking some time, and I'll be sure to get your contact information out there, you know, afterwards, so people know how to get a hold of you, and you can actually get paid for your advice in the future. But for today, thank you for joining us, and I thought it would be appropriate to maybe do some opening statements. We could go, Matt's first on my screen there, Matt Jameson. You want to kick it off?
Sure. Thanks, John, for setting this up. And Micah, glad to hear that you enjoyed the last time we did this and found it worthwhile. It's certainly been an interesting year for the construction industry. I think at least from the clients that I'm working with, most of the clients have actually had a pretty good year. I think, you know, clients are worried about the future in terms of their backlog, perhaps not being as strong as they'd like it to. But I really think the industry has done a great job of adjusting to COVID. One of the issues, I guess, to kick things off that I've been dealing with most frequently recently related to COVID are price escalation clauses based on the you know, lack of availability or potential dramatic fluctuation in prices of materials. We've seen that a lot with lumber. And I'm seeing it with some other materials as well. I wanted to mention the consensus docs 200.1, which is a potentially time and price impacted materials amendment that they've set out. It really is more of a structure in terms of how to address it, as opposed to, you know, a detailed recitation of exactly how to deal with those issues. But basically what it recommends is establishing a baseline price for the materials that you are worried about, and then establish a basis for equitable adjustment. And that, I think, is part of the challenge. You know, for certain materials, there may be a material cost indice that you could use, a generally accepted trade indice. For other instances, you may need to rely on a, you know, web-based price index. And then the amendment also provides for a percentage cap on both increases and decreases, and it does not provide for any increase to overhead and profit, so that the owner takes some comfort in knowing that you're not using this price escalation as a way to increase your profit on a job. The amendment also provides for a time extension for availability problems with certain materials. You know, one of the things that's left open in the amendment is it just an extension of time, or would there be any additional compensation, for example, for extended general conditions as a result of a delay? And that's not addressed in the amendment. That's certainly something that the parties should address if they're going to enter into it. I've also suggested to clients considering a substitution provision to the extent that, you know, you may have the ability to substitute materials to avoid a significant price increase. You also could consider making the owner responsible for purchasing certain materials that would place that risk on the owner and protect the contractor. And it also may give the owner more comfort, again, that the contractor isn't sort of gaming the system to try to increase the cost. And I've also recommended to certain clients that they consider providing the owner with a right to make scope reductions to hold the total price where it is. Particularly if, if an owner has already finalized financing on a project, they may not have the ability to fund a significant price increase to the total cost. So if you provide an opportunity for the owner to make a scope reduction to hold the total cost on the project, yet still deal with the price escalation for those material components, we've been able to negotiate those in certain contracts. But that was the one issue, John, that I wanted to be sure to mention that I've been dealing with, significantly in my practice as a result of COVID.
Thank you, Matt. Again, that was Matt Jameson from Burns White. Why don't we jump from Pittsburgh, where Matt is, and we'll go to Camp Hill with Tom Williams of Rieger Adler. Tom, welcome.
Thank you, John. And again, thanks for getting this together again. Good morning, everybody. Matt hit on, something that's clearly a direct result of COVID. One thing I just wanted to add to that is that before I get on to another topic is a lot of times I find that contractors are so focused in their change orders that they're so focused on an increase in the price. But yeah, it's something that's really important that people need to focus on in the change order, whatever form it is. Make sure that you also at the same time, if appropriate, increase the time that you have to perform. Because I've seen several change orders come back where, the focus was, wow, this is going to be an increase in cost to me. And they get the increase in cost, but, you look, if a dispute arises sometime later in the project, you look at the change order and there was no reservation for a change in the number of days or the completion date. So I just wanted to bring that up. Now, something that's very, very timely. In fact, just an article came out yesterday, April 27th. Wanted to talk a little bit about the Attorney General's prosecution of violations of the Prevailing Wage Act. It's a pretty scary thing for contractors. There's a couple of cases ongoing, and you may have heard the words Goodco Electric and Hawbaker Inc. They were alleged to basically not just violated the Prevailing Wage Act, but they are being prosecuted criminally for theft of money. And the way that has come about is that, at least in the Goodco case that I'm more familiar with, basically there was an alleged misclassification of workers, and the allegation from the Attorney General's office is that, hey, Goodco and Scott Good, the president, benefited by basically pocketing the money that should have been paid out to workmen by, mischaracterizing or misclassifying workers as laborers when really they were, in fact, electricians, or at least doing electricians' work. The prosecution has ended, and there's been a plea as a settlement. And not only is Goodco obligated to pay a rather significant fine, but Scott Good, the president of the company, is actually going to be doing time. Wow. The sentence is between 4 months and 2 years. And if anybody is familiar with L&I, the way these things used to be dealt with, of course, was labor and industry would say, hey, we were given a referral or a complaint by a workman on X project, send us all your documents, or telling you that, hey, we're going to be in your office to look at these documents. But then there would be, some due process there, hearings, and whether or not there was an actual violation, and whether that violation was intentional. If it was found to be unintentional by L&I, there would be no debarment, but that's as far as it went. A fine, payback of the wages that were underpaid, and potential from being debarred from doing public work for maybe up to 5 years. But there was never the possibility up to now that you would lose your freedom and be incarcerated. So the Attorney General is being very aggressive with this. And now that the Attorney General has this particular case in his back pocket, he's going to be even more aggressive. And not only the Attorney Generals, but there are some district attorneys also that are glomming onto this theory of it's not just a violation of a civil statute that you didn't pay this guy the right rate. It's you are criminally liable for stealing money of individuals that have earned it. So it's going to be Katie bar the door, I think. It's only going to get more pervasive, these criminal prosecutions. And people need to make sure that they cross the T's and dot all the I's, and make sure that they're doing their paperwork and prevailing wages properly. And one practice that I hear of now and then is that folks that aren't sophisticated enough in their office and doing prevailing wage work, or just get lazy, they have their men do a ratio every day. Okay, Johnny Smith worked 7 hours as an electrician and 1 as a laborer, 7-1, 7-1, 7-1, and they do that every day. That's a huge red flag. So it's imperative that you classify your folks and have them sign off on their own payroll as to what they were actually doing for each of those hours worked. It's cumbersome. It may be a pain in the neck for your foreman or whatever, but you need to have actual contemporaneous records of what classification your folks were doing work in each hour, so that you have a pretty good defense set up. But I just wanted to bring that up today. It's very timely. I don't know the companies that are represented on the call today, how much prevailing wage work you do, but the warning signs are out there. There's flashing red that not only your company could be potentially debarred through an L&I type procedure, but now a district attorney or the Attorney General can prosecute you. And if you're the president of the company, or presumably if you had a role in defrauding or stealing money from employees, you could be facing jail time. So on that happy note, seriously, I wanted to get that out there because some may not be aware of it. And since this is being recorded for posterity, others that might tune in later that do prevailing wage work and don't have the back office that maybe they should. It's a whole new ball game now.
Hey, Tom, just wondering, did they have to prove intent on that?
Well, what's interesting, again, I believe in any prosecution, any criminal prosecution, you have to show intent. But this was a plea deal after, I think the case was brought in 2019. So, and the word I'm hearing is that the the Attorney General was willing to settle with Goodco and their lawyers a couple of times. And I don't think that that settlement discussion involved jail time. But the judge, and I don't recall the name of the judge, but the judge, again, what I'm hearing is basically took it upon himself and said to the Attorney General, well, if this company did what you say they did, there should be jail time. So he disapproved the settlement. So yeah, to answer your question, I think you got to show intent, but Scott Good, he obviously, through a lot of sleepless nights and soul searching and talking with family and everything, probably, he made the deal that he thought was appropriate to get this thing behind him. And now he's facing, 4 months, potentially up to 2 years.
The problem with Scott Good, though, he was vice president of Allied Mechanical, which was also prosecuted for the identical same crime. And he perjured himself when on trial. So there's a lot more extenuating circumstances than just prevailing wage.
Well, that certainly may be, Bob, but I don't think it entered into this particular case. I mean, each case has got to be taken on its own merits, and I don't even know that judge knew anything about that history or took that into account. I don't know that.
But he'll look that up for sentencing money.
Well, again, the sentencing has been set 4 months to 2 years.
Thanks, Tom. That's Tom
Bet.
Williams, Rieger Adler. And I actually prepared a list of questions in case I need to break the ice. And topic number 1 was price escalation, which Matt covered. Topic number 2 was actually a prevailing wage, and get your guys' thoughts on this topic. So let's see if Dave talks about requiring vaccination for number 3 here. So next up, we're going to jump back to Pittsburgh and hear from Dave White at Babs Callan. Dave, welcome to the show.
Thanks, John. I wrote down a couple of things that I thought were prevalent with some of our clients, and one of them was the materials and the unavailability of materials and price escalation. So Matt, thank you for yet again stealing my thunder. I don't want to go after Matt ever again, John. It just happened when I worked with him, and now even when he's not here anymore, he's continuing to steal my thunder. And it's interesting though, I actually hired I was talking to an interior decorator just to do some minor work around my house. I have a new girlfriend, and so of course my whole life is changing. I'm dressing well, and I have to redo my kitchen. And one of the things they said to me is, there's a major wood shortage. So it's drifting all the way down to even the interior decorator. It's just interesting to me that I didn't even put 2 and 2 together until. So certainly that's one of the issues. The other issue that I wrote down is, and I don't know that there's really a lengthy discussion about this, but the fact that just how the labor pool continues to get older and older, and there's just a major lack of younger skilled labor. And I was over at the ASA, and we're having some discussions about that. And it's always great to point out the problem. Then the question is, what's the solution? And they were talking about how they're trying to educate people, get out there, explain it, because every parent wants their kid to go to college. And I've seen firsthand kids that should never go to college, that should be, I don't want to say the trades. I mean, there's different options, but that's one of them. I'm always saying, hey, this is the way to go. You get in and you get trained and start making a decent wage, and you can support yourself. So, that was the other item I mentioned. I'm sure that's something on the radar of our participants. The one thing, and I don't want to go on and on, but one of the things that I thought may be of interest is just what I'm seeing just legally in the legal community and so forth. And the one thing I've been seeing is how well people have adapted to Zoom calls, Zoom court hearings, Zoom depositions, and that rather than having to travel across the state or out of state or so forth, that we're able to do this, which saves, frankly, a lot of money and time involved with that. And so people have adapted. You know, I'm not saying anything that nobody's seen, but that was one thing I've noticed. And then I guess the other thing is with just cases. I mean, I've been busy, and I've talked to a number of my contemporaries, and they're all pretty busy right now, and that goes without even cases really advancing to trial or anything. I mean, you've got cases that are filed, and then you file the pleadings, but there's no real deadline where you're going to trial or anything. And so what I've seen is that there's much more of a willingness to actually sit down and try to resolve the case amicably. There's a lot more mediations. So that was kind of what I've been seeing, that people don't want to just fight for the sake of fighting, because at the end of the day, there is no end date. If you can't get a trial, and people are like, what are we going to do? We can't get a trial date. I had a case scheduled for September, November, March. Now it's on November's list. So it's been pushed back 14 months, and you're getting nowhere. And the other side, who is the one seeking the money, just keeps trying to settle and resolve the case. And that makes sense because, without some kind of a final determination in court, what are your options? And probably to settle. So those are really the things that I've kind of seen.
Yeah, Dave, I actually been talking to in reviewing some contracts. I've been talking to clients that maybe have historically not been fans of arbitration, and saying, well, sort of be careful. If you want a dispute resolution process that's actually going to resolve your dispute, you maybe ought to think about arbitration. Because if you're hell-bent on going to court, given the delays and the backlog in the courts now, probably going to be a really long time before your case gets heard.
Yeah, that's a great point. I mean, I'm not a big fan of arbitration from the standpoint that if you have a good legal defense, and then also I find that sometimes the cost is just as much and you don't have really any recourse, but that's exactly it. I mean, if you want to get in front of somebody and get it resolved, that's the way to go. So yeah, that makes sense, Matt. It's interesting that people are writing that into their contracts.
Thanks, Dave. That's Dave White from Babs Callan. And last but not least, we're going to jump back from Pittsburgh and go to the eastern part of the state. I think Mike was outside of Philadelphia today, or maybe he's in the Harrisburg office. He kind of flies all over the place here. But Michael from Cohen Siglius, welcome.
Thank you, John. And I guess I'm batting cleanup here. So essentially that's what I'm going to do, because talking about Dave's point about stealing thunder, I think the three co-panelists have all hit upon the major issues that are presenting everyone. So I'm going to add just a little tidbit to each one of those, starting, of course, with my location. Today, I'm actually in, I guess, our firm's Berwyn office, which is where I live, about a third of the way between Harrisburg and Philadelphia. But that's right, I do head off to Harrisburg. We've been in our office in and out, but it varies according to circumstance. But to Dave's point, you're right, at least with the fact that I've got the virtual background and everything, you would never really know. And I think that speaks to something that these virtual connections will, I think, moving forward, become not only a part of legal work, but also a part of the construction industry and how it operates. So it's something to get used to. It is a tool, but it shouldn't be the exclusive tool. And I think it's fortunate that we're finally moving out of that as a mechanism. We have all the full array of tools that we would want in front of us. To Matt's point about price escalation, one of the things, and to take a broader picture on this, one of the things I'll never forget from the first year of law school is that contract law is for control freaks. And that is to say that you can make the contract whatever you want. And it's great that Consensus Docs has their own version of it, AIA has their own version, but don't forget that for whatever circumstance you're facing, you can find a contract and contract language on price escalation or any of the other COVID-19 issues that are confronting new projects now. you can find whatever language you need. And so don't feel like you're beholden to whatever consensus says and whatever AIA might say. Matt and Tom and Dave all probably have done this as well, but we've got thousands of versions or hundreds of versions of different language, and we'll probably be creating new language going forward as to how to resolve each particular circumstance in a contract. As to Tom's point about the AG, I know that my colleague Chris Carasone produced a piece that analyzes this growing trend of criminal prosecution, which is the novel part, as Tom pointed out, for prevailing wage violations. The one point that I would emphasize is that this advance by the AG might not be on a solid legal ground as otherwise thought, that it is a novel approach. And so there was an analysis that Chris did about the authority underlying that. And I think that would give avenue, depending on the case, as to how you would defend it. Tom brings up another great point about the mechanisms and systems you have in place. Borrowing from an analog from something that I do in my practice with a lot of OSHA compliance and OSHA citation defense, if you've got systems in place to keep workers safe, that can be a defense. And I'm oversimplifying it, but that can be a defense. And I think similarly to what Tom was saying about the intent issue, if you've got the right systems in place to properly classify workers, and for whatever reason you get confused, and quite honestly, I can't see who wouldn't be confused sometimes by prevailing wage and some of the details that go into that, then I think it is a help to counter the intent element that I think that Tom had rightly identified as necessary to any kind of criminal conviction. So again, that is something that you're going to need to develop going forward to make sure that you have the right process in place above all else. I too have been hearing all kinds of information about workforce shortage, and I think that speaks well for the industry, at least for central Pennsylvania. ABC yesterday just did a great presentation about ways to combat that workforce shortage. One of the things is changing the approach to whether people with a criminal record should be allowed to be on job sites and to work. It raises a problem, however, and I say this as a former teacher and somebody involved in the education industry, as some of you know, no one's allowed on a school without proper clearances, and some of that includes a criminal background check. So you see sort of a conflict between wanting to hire re-entering felons, conflicted with the fact that there might be certain administrative processes, at least with school-related work and perhaps other public work, where that record might be getting in the way. And again, it's another issue that I think we're gonna have to resolve from a policy perspective. But that is one avenue of opening the labor market. Regardless, everybody's busy and everybody's looking for workers, at least in central PA, at least for the short term. The long-term analysis and projections are different, but I think some of that will be tied, I hope, to the infrastructure bill. The bigger picture with all of this that I've seen is that I think, at least what I'm hearing from talking with people, is that at least for the past year, there's been a great deal of going along to get along, or vice versa. And that is to say that in managing the additional costs that COVID has created, whether it be by price escalation or by delays or by labor shortage or by safety requirements through COVID, all of which has been identified, the question becomes, well, who's paying for that? And I think a lot of that has been shared. To me, I'm thinking about my clients, and I think as we all do for our businesses, we need to think about the extent to which that sharing is fair. And certainly there's contract language that can address that. And so the other thing I would encourage people in the industry to think about, and we handle the four panelists, we handle the legal perspective, but we do that as a tool to make sure, and Bob Dresser, forgive me, because we were talking about this, but to make sure that you maximize your profit on your job to the extent that it is fair. So we've all been burdened by this COVID circumstance. We need to make sure that you use your legal rights in your contract, whether in negotiating it going forward or the ones that are existing on projects, to make sure that your fair share of profit on a job is there. So the legal process, legal services that all four of us provide aren't necessarily about claims or disputes or technicalities, but really big picture is to maximize that profit. And again, shout out to Bob Dresser. We had lunch last Friday and we're talking about just this very topic. So I know that's getting at a higher elevation as it down into the details, but I think everybody else covered some of those details. I'm offering you a thought as to why that's important. So I know, John, perhaps you have some other questions, and I and everybody else is, I'm sure, looking forward to answering them.
Absolutely. Thank you, Michael. I want to be respectful of everyone's time, and end this at 11, because we all have busy schedules. And I also want to be respectful of our contractors on the call and our attendees on the call. And I realize we could go in many different directions. We could talk prevailing wage, workforce. These guys brought up great topics. So I was just wanted to throw it out to, Micah, Bob, and others on the line. Is there a certain direction, certain topic you guys would like to discuss?
Well, one question I had is, when do you guys see the courts getting back to normal as far as opening up to society and everything else? And is that July also, or is it further out than that?
Bob, I would say region by region. Philadelphia is more densely populated, so that they're going to take a longer time to get up and running. I think my impression is that some of the less populated counties or less densely populated counties, those court systems can get back up and running, especially too, depending on vaccination rates and infection rates out there. And as well, the court's comfort with the masks and other safety provisions. It's comfort with allowing people to be in the courtroom with masks. So so in my matters, I've only got stuff in Philadelphia right now, at least that's moving forward to trial. I've got another one that's in Cumberland County, and we haven't heard anything there about where that court's going to proceed. But it goes back to what Dave was saying, is that you got a lot of things that go on before trial that certainly keep all of us busy.
Yeah, I would just add that it's going to roll out on a county by county basis. All these president judges, and they all like to have their own little fiefdoms, and you're not going to get the Supreme Court of Pennsylvania, for example, saying this is when all courts are open. It's not going to happen that way. It's going to roll out on a community by community, court by court basis. I guess it kind of raises another issue though, and maybe it's when you're in litigation. I mean, there's one issue as to when the court will be open for normal business, but as we all know, when you're in the middle of a litigated case, you're talking about discovery and you're talking about depositions. I foresee in our attempts to get folks into an office to be deposed, I could see the tail of COVID lasting a lot longer now. Whereas, even though the courts are open, I could see if you were going to notice someone for a deposition, you would get potentially an objection saying, hey, my client does not want to go to your office and sit for a deposition because of, we don't believe you have enough room there, or my client has a certain condition, and that we're going to insist that the court order that my deposition, whether it's next week or 6 months from now, potentially, that we're not physically going to go to that lawyer's office for a deposition. We want the judge to order a Zoom deposition. And whereas, in some cases, it's not a terrible thing to do a Zoom deposition. We've all done them. They can be cumbersome. But in some cases, and I've got a few that are not construction related, I want to eyeball the person that I'm deposing. The client wants to, and I think there is a great benefit often to the parties sitting across from one another, because it may be the first time that the president of party A and the president of party B have actually eyeballed one another during a deposition, whereas prior to that, they've been getting all of their information either filtered through an attorney or through a key person in their own office. So I think there's a great benefit to having depositions live, if you will. And I could see that the COVID may offer some people that may not want to do that and may want to just be on a screen somewhere remotely and not subject to any personal contact. I could see that lingering on. So that's going to be something that we'll be dealing with, I think, for some time. I don't know if you guys have thought of that aspect or experienced it already, but I know that I've been holding off on scheduling a couple of depositions because I want to be able to do them physically in my office.
Well, the only thing I'd add to that is that I'm seeing now that courts are going basically month to month. Like Allegheny County just extended their shutdown through the end of May, which has been sort of the smallest bite that they've taken. In the past, it's been 2 or 3 months. So I think that that's an indication that they're looking at this on a month by month basis. But I certainly think to some extent, all of these courts are going to be sort of the tail, and the dog is going to be, the county itself. Until the county opens up to a greater degree, the courts are just following along with whatever the county's doing. So I don't see any of these courts being affirmative and getting out in front of what the general county regulations are doing. So I'm guessing we're looking at July at the earliest, because I agree with what Michael said about some of these smaller counties, may be in a position to open earlier because they're lower population. Unfortunately, I think if you look at the vaccination rates, some of those same counties are lower vaccination rates. So that sort of balances against maybe opening earlier. So I think
Well,
the very earliest.
It's interesting, Matt, it's not only some of these counties are opening up, and then the big question is whether or not you're going to be able to get jurors to come.
Right.
And so I wonder just how strict courts are going to be about requiring jurors to show up for trials. I mean, because the one thing I've noticed, I don't want to say the one thing, but one of the things I've noticed is that courts are much more willing to grant extensions. And I think Michael touched upon it, the new, how everybody seems to be getting along. And it's the same thing in court, that if you need an extension, the court's been willing to grant it because there's really nothing pressing. And so I wonder just, how strict they're going to be about keeping the time schedule. And Bob, I mentioned that case that was scheduled for September, moved to November, moved to March, and now the courts are looking at a November. That's federal court in the Western District. So I think that, I think the answer, maybe try to answer your question directly, which I think that sometime in September or October, we're going to start seeing a return to normalcy. That's a blanket guess, but I can't say for certain.
My sister who lives in New Jersey just got noticed for jury duty, and they're going to do it by Zoom. I don't know.
Oh, really?
Yeah, in New Jersey, they're going to do jury trials by Zoom.
A contact of mine on LinkedIn just completed a jury trial by Zoom. So yeah, that's how they do it.
It's interesting too that if you're in a hearing, are you really? I don't want to get into constitutional issues and due process rights and all that stuff, but just to have a Zoom trial to decide something so important to you, is that really the right thing to do? And obviously, if you win, it was the right thing to do. But if you don't, then like, holy heck, what just happened? And that's going to be interesting. Really getting called and because I don't know how I would personally feel about it if I'm getting sued for something and okay, we're going to do this by Zoom, and you've got to show up. You don't have really any choice. Interesting. That's an interesting thing, Tom.
Thank you. I see Bob Dresser unmuted. Bob might have a question.
Yeah, I do. It's a different avenue. Change directions here, if you guys don't mind. Tom, by the way, it's good to see you again. It's been about 1.5 years, I guess. But anyway, I'm Bob Dresser with Strategic Executive. One thing I do amongst being a construction advisor is I am a construction industry expert witness as well. So this is very interesting. I guess my two-part discussion or questions is number one, I think whether it's materials or workforce or any other topics you guys mentioned, I think you drove home a key component is that getting your contract formation right on the front end can save you a lot of issues on the back end. It can also set the stage, as Michael said earlier, to maximize your profits, whether it's change orders or change management or anything like that. The second part I'd like you guys to discuss is I see the industry, construction industry and project industry, if you will, evolving more into a collaborative contracting model, whether we call it IPD, Interactive Project Delivery, or even multi-party contracts where it drives collaboration and a spirit of helping one another. Do you guys see much of an uptick in those types of contracts? I think it's gaining popularity is up from my eyes in education and in healthcare. I was just wondering if you guys are seeing similar trends.
Who wants to go first? Michael just unmuted, so.
Yeah, I'll just chime in. I think some of you who've been involved with KCA over the years have known that we did several seminars on IPD, and that certainly involved a lot of work that was going on at Penn State. My only concern about some of that is with that collaborative approach is what happens to, and this might just be a lawyer's reaction, but I think it's a valid one. What happens when the majority wants to go in one direction to the unfair advantage of perhaps a minority? The whole reason we have a legal system is to protect that very circumstance, that there is a way to redress and create fairness for those rights, at the risk of getting too philosophical here. So I think that's just the only caution I would have about it. But again, it goes back to a two-part answer that Bob, I think, already provided. One, you make sure that your contract allows for some mechanism to have that protection, and as well, you make sure that you have an advocate or a voice in the room when those conversations, those collaborative conversations, are occurring, to make sure that there is true fairness for everybody involved. And again, by fairness, sad to say, it's maximizing profit, but that's why you're all in business. So again, a very big picture answer, and really just a matter of getting to it is drilling down some of the details we talked about earlier as a project evolves, and it's project specific, of course.
Anyone else want to? No, Matt, go ahead.
Yeah, Bob, my 2 cents on that is, yes, I think we are starting to see more of that. And I think the reasons are because a lot of the issues that we've been talking about today, when you look at extreme price escalation risk, the idea of how do you manage that, it frankly makes a lot more sense if you manage it on a project-wide basis, so that it's a risk that every player in the project is assuming, as opposed to trying to contractually allocate that risk to one entity. Same thing with, like the issues that we were just talking about with the lack of access to courts to resolve disputes. If you're really not going to be able to get in any kind of a prompt basis to get your dispute resolved, does it make more sense to look at a different way to skin a cat? An IPD maybe providing a mechanism to try to resolve those problems, during the project on a more equitable basis with a sharing of risk and sharing of reward. So I think that we are seeing more of that, and I think that we'll continue to.
Thanks, gentlemen.
Yeah, I just have little feedback there, Bob. Just to your other point about contract formation. It's interesting. I have a couple of cases where I don't understand this love affair with MSAs that all these owners seem to think that's the way to go. But it's amazing to me. It seems like every time I have one of those, it's entered into with a parent company on behalf of their affiliates. The affiliates entered into the agreement with the contractor, and then whatever was supposed to be incorporated is not incorporated. And so I agree with you that contract formation is very important. I'll say, okay, well, where's the contract? Well, here's the purchase order. Well, I'm sure the purchase order incorporates the contractor's proposal. No, it doesn't. I'm sure it incorporates terms and conditions. And so they just get into a mess. So that's a very good point that you made about contract formation. And a lot of times it's people doing that. And I'm not saying that any of us are trained any better than the next person with doing it, but at least over the years we have experience dealing with it, and we know how to do it. A lot of times people doing the contracting are not lawyers or people that are used to doing it. They're just slapping things together, getting it out the door. I mean, I've reviewed contracts for clients that have, section 1, and then the next one's paragraph A, and then the next one's clause D. And I'm like, where'd you put this together from? Like, oh, we pulled a bunch of different provisions from the internet. So it's good for business. I mean, because then you have all kind of arguing over the contract, but up front, you're right. I mean, work on that up front.
Dave hits upon a point. I don't know, Tom, if I'm cutting you off, you want to jump in, but that I've said many times to people in the industry is that investment in contract review, $1,000 to $3,000, maybe more, can save you 10, maybe even 100-fold for just the reasons that Dave's talking about. It is a worthwhile endeavor to do that, and same too with consultation throughout the contract, the construction process. Excuse me. Is valuable. One of the issues too that I know that John raised, I think really actually in some respect can go back to contract formation, is the issue of mandatory vaccinations. I know that we've had previous discussions about whether an employer can do that. An issue has come up as to whether the owner who is contracting with a general contractor can impose that requirement on the general contractor that all of its employees, or its subcontractors for that matter, and their employees be vaccinated. And the answer is yes, but I think the same exceptions that we've talked about with the employer apply, whether it be an exception for religious reasons or medical reasons, and in particular medical conditions, and also a nursing or pregnant mother. But the reason, you just want to make sure that your contract language allows for that, although usually they do, in that there will be no imposition upon a general contractor to violate the law. And since those exceptions arise out of Title VII and ADA, I think that would be your safe out. There is a consideration you might want to consider putting those exceptions expressly in there, so that there's no miscommunication and no issues further on down the road. But that was something that I think that it had come up, and I was able to did some digging around, and that is at least the short answer on how that issue plays out. I think obviously it would be project specific further on down. So I don't know if any of you guys ever looked into it as well, but that's the long and short of it based on my investigation.
Thanks, Michael. Yeah, I heard from a few GCs this week, I guess with certain colleges are requiring students to get vaccinated when they return in the fall. And the colleges are giving thought to whether they should extend that requirement to contractors and service providers that step foot on the campus. So you'll probably hear more of that over the next few months over summer. We have a few minutes left. Any remaining questions? Micah, this was your idea to host the event, so I'm sure you got something good, brother.
Hey, I started out with a question, remember? Now, I was wondering, Bob had brought up the more collaborative project deliveries and so forth, and this isn't related to COVID or anything, but is there a measurable difference of contract litigation, dispute, and so forth between those collaborative project deliveries systems versus traditional design, bid, build projects? Is there anything measurable as far as contract disputes, as far as a difference?
Mike, my 2 cents, I think that's a great question. Unfortunately, I don't know the answer to that. I would certainly say that in our region, we don't have enough of a base to make any sort of statistical analysis, because there just hasn't been enough, IPD projects within our region. But I don't know if anybody's ever studied that for example, on the West Coast where it's been, more heavily used in recent years. I'm actually working with a lawyer out in LA on a case, and I'll shoot him an email to ask him whether he has seen any studies on that. And if I get any kind of feedback, I'll circulate that to everyone.
Yeah, and I don't think it has to be just IPD. I mean, it could be design build, CMAR, whatever.
Right,
just
right.
a more collaborative, where everyone is in the room together early and often, and they're a team before the project starts. So I just wonder if that makes a difference as far as contracts and so forth.
Yeah, one of the things too, I might, not to get too academic about it, but is how do you define disputes? A disagreement among all those people in the room, Micah, does that count as a dispute? Because you're right, some of the formal processes might not be there. And so that's sort of I think those collaborative approaches might redefine what we call as a dispute, because they're redefining the processes by which the project is completed. So another point.
Yeah, I think maybe dispute is wrong. The more cumbersome effects like legal, I think legal disputes is more what I'm talking about, not negotiations, but more legal kind of disputes.
Now you bring up a good point. I think IPD and those collaborative approaches change, I think, the perspective and the approach that we as servicers to the industry need to provide. We need to adapt to that changing environment.
Good question. Thanks, Micah. Well, we reached the 11 o'clock hour. Do we have one final question?
When you guys were talking about the owners requiring COVID testing or vaccination, you guys didn't give us the answer. As an employer, can you refuse to employ a person on a project because of that?
Well, I'll give you my opinion on that one. I think especially if you have owners that are requiring that on their projects. For example, if you're working on, primarily healthcare projects where that's being required, you most certainly can require that. I think it's interesting. You also can require your own employees to be vaccinated. I think it's been a little surprising to me how few companies have done that. I think most companies have taken the approach of making it a recommendation. And I think the fear on that was, if you do make it a requirement and someone has a problem following the vaccine, you certainly could be looking at a workers' comp claim, which I think is why most employers have taken the recommendation approach. I have seen some employers offer rewards, whether it's an extra day off to recover from the vaccine or even a cash bonus. And all of that is permissible. There's no problem with any of that.
And Bob, just to follow up, as we were talking about before, you can require it as an employer, but you have to allow for 3 particular exceptions. One, a religious objection, and then 2 other medically related ones because of the Americans with Disabilities Act and Title VII. So some people have gone as Matt was just talking about, the incentive and the recommendation approach, because they avoid then having to get into ADA and Title VII issues, which can add cost to the process and can create additional headaches for HR. I think with sufficient incentives, just the fact that you can walk around without a mask, I think that can be a great way of encouraging employees to get the vaccination. But if the owner's requiring it, then I think really you have little, if any, choice other than to hope your incentives and recommendation approach gets 100% compliance with your employees.
Thanks, Bob. Good question. Thanks, Matt and Mike, for your feedback there. We're a little past time here. I just wondered if our panel, wanted to maybe spend a quick 30 seconds just to close out. Any final thoughts? we'll go reverse. Michael, you want to make it quick though?
Yeah, there's a lawyer 30-second and there's a
Yes.
civilian or layperson 30-second. I'll just say thank you everybody for the opportunity to be here. I will say that I'm just to give you an idea of how much COVID still is around us. The whole reason I'm working from home today is that my daughter was in close contact with somebody in her school who contracted COVID-19, and the dominoes fall from there, and then I'm stuck at home for the next few days. So it's not going away just yet, but we're getting there. And we just need to continue to keep an eye on how it affects the industry. Pleasure talking with everybody as always. All four of us, I'm sure, love these topics. I'm sure the guys have things to say too.
Thanks, Michael. Dave?
Just FYI, I don't know who all has been tested. I was potentially exposed in between my two vaccines. So I was still, obviously not fully immune. So I went to CVS and they were able to get me in for a rapid test within a day. So just if anyone wants to look at that.
Thanks, Michael. Or was that Dave? Dave, you sound a little different there. Was that you?
Yeah, I like Micah's voice a lot better than mine. So his is cool and deep and full of authority. But anyway, John, thanks a lot. I don't really have much to add. I mean, we've all been going through a lot of stuff. I'm 2 days away from being 14 days out from my second test. So I'm hoping that everything goes as well. I'm just holding my breath. I've had a couple of daughters that have tested positive and somehow I've avoided it. So stay safe, everyone. And thanks again, John. And I look forward to the next time we get together.
Thanks, Dave. Tom? Oh, you're muted, Tom. Tom, unmute.
There we go.
All right.
So, hey, I'm still working on the Zoom stuff. So anyway, as we all are. But yeah, it's been a pleasure. Thanks again, John, for the opportunity. Really enjoy the give and take with the professionals in the industry and we attorneys, and we try to work together on coming up with the right answers for everybody. I just hope for everybody that your families are doing well and that your businesses continue to thrive. See you next time.
Thanks, Tom. You want to bring us home, Matt? With the big
all right, John.
Here.
Yep. Thank you very much for setting this up. Nice to see everybody again. The last thing I would mention is just real quick, invest in technology. Michael touched on this earlier, but I think the idea of Zoom meetings, Zoom project meetings are going to be here to stay. I think we're going to see expanded use of drones in the future for construction inspections. And I also think we're going to continue to see a push to greater prefabrication and more modular construction. I drove past a parking garage on the North Shore that I swear was built in 2 weeks. It was insane. And, obviously everything was all, prefabbed and then just put together on site. But I think we're going to see more and more of that. And I think that will be a continuing change that was perhaps triggered by COVID, but I think we're going to see it more in the future. But thanks again, John, and great to see everybody.
Well, thanks to each of you. And on behalf of the KCA, we're glad to be associated with such knowledgeable and smart people like yourself. And thanks for educating us today and taking a little time out of your schedules. Have a great day, everyone. Take care.
Good seeing everybody. Take care.
Thanks, everyone. Good to see you.
Oops.